Hello students, your topic for today is liability to pay compensation in certain cases on the principle of no fault. So section 140 of the Motor Vehicle Act 1988 deals with the liability to pay compensation in certain cases on the principle of no fault. Subse- Subsection 1 of Section 140 means says that where a death or permanent disablement of any person has resulted from an accident arising out of the use of motor vehicle or motor vehicles, the owner of the vehicle shall, or as the case may be, the owner of the vehicle shall jointly and severally be liable to pay compensation in respect of such death or disablement in accordance with the provisions of this act. So whenever there is a death or permanent disablement of any person that is occurred due to the accident that has been arised by a motor vehicle or by motor vehicles, then jointly or severally the owner of such vehicles or motor vehicles will be liable for the injuries of disablement or for the death. Then subsection 2 of section 140 states that the amount of compensation which shall be payable under subsection 1. So this is talking about the amount of compensation in respect of death of any person. It is fixed sum of 50,000 rupees, and the amount of compensation payable under subsection in respect of the permanent disablement of any person will be 25,000 rupees. Then subsection 3 states that in any claim for compensation under subsection 1, the claimant has to is required to plead and establish that the death or permanent disablement in respect of which the claim has been made was due to any wrongful act, neglect, or default of the owner or owners of the vehicle or vehicles concerned or of any other person. Subsection 4 is that if a claim for compensation under subsection 1 shall not be defeated by this reason of any wrongful act, neglect, or default of the person in respect of whose death or permanent disablement the claim has been made, nor shall the quantum of compensation recoverable in respect of such death or permanent disablement be reduced on this basis of the share of such person in the responsibility of such death or permanent disablement. Then subsection 5 states that notwithstanding anything that is contained in subsection 2 regarding death or bodily injury to any person for which the owner of the vehicle is liable to give compensation for relief, he is also liable to pay compensation under any other law for the time being in force, provided that the amount of such compensation to be given under any other law shall be reduced from the amount of compensation payable under this section or under section 163A. So section 140 deals with liability without fault. It talks about death or permanent disability of any person arising out of the use of the motor vehicle. The owner shall be jointly or severally liable to pay the compensation. If there is death occurrence, then the liability is fixed as rupees 50,000, and if there is permanent disability, then the owner is liable to pay 25,000. So under this section 140, the claimant is not required to plead negligence on part of the owner or driver. The claim for the compensation by the claimant is not defeated by wrongful act, neglect, or default on part of the person who suffered death or permanent disability. This section also provides for claiming compensation under other provisions of the same act or any other provisions except section 163A of the Motor Vehicle Act 1988 that would provide relief in addition to the fixed amount provided under section 140. So the amount of compensation to be given under any other law is deducted, reduced from the amount of compensation payable under this section. The provision that deals with interim compensation were also added in 1994. So the phrase accident arising out of the use of motor vehicle means, and it is used to widen the applicability of the section. The word use has a wider connotation to cover the period when the vehicle is not moving and is stationary, and the use of vehicle does not cease on account of the vehicle having been rendered immobile on account of a breakdown or mechanical defect or accident. So the accident should be connected with the use of motor vehicle. The connection need not to be direct and immediate. The expression used enlarges the field of protection made available to the victims and is in consonance with the beneficial object underlying the enactment. That's all. Thank you.